Thank you.
Hi.
Okay. I believe we have our live stream. Welcome, everyone. I am Sarah Posey, the lead administrative law judge for this appeal. And with me today are panel members, Judge Teresa Stanley and Judge Eddie Lamb. I want to thank everyone for joining us today. Before we go on the record, I just want to go over a couple of things together and recap where we are in the appeal following our pre-hearing conference. Once we're on the record, we'll do formal introductions and we'll get to our presentations. Just briefly, the Office of Tax Appeals will be conducting today's hearing electronically with the agreement of the parties and participants. I do want to note that present is our stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speak one at a time and do not speak over each other. Also speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the Ms. Alonso will produce the official hearing transcript, which will be available on the OTA's website. So during today's hearing, we ask that you say your name each time before you speak and mute your microphone whenever you're not speaking, so we avoid feedback and background noise. Again, today's proceedings will be live streamed and the video recording is part of the public record and will be available online. So, any questions before we move forward? Okay, so I'm the lead judge for the purpose of conducting this hearing, but all three judges on the panel are co-equal decision makers and may ask questions after our presentations. So the panel has read the briefs and examined the exhibits in preparation for today's hearing. So I want to go over the exhibits together before we go on the record. At the pre-hearing conference, we noted that FTB submitted exhibits A through D, and appellants submitted exhibits 1 through 5, which we renumbered. And then after the pre-hearing conference, appellants submitted additional exhibits. An additional revenue and tax code section 19050 to be added to exhibit 5. And then they also provided some documents regarding Brent Lance, which we called exhibit 6. So let me go to appellant. Did I have that right?
Yes, that's correct.
Okay, good. And then franchise tax board, did you receive those documents?
Yes, we have received those documents.
Okay, thank you. Do you have any objections to the original or additional exhibits 1 through 6?
No objections. Thank you.
Okay. And then same question for Mr. Gozlan. Did you have exhibits A through D, correct?
A through D, yes.
Yeah, from the franchise tax board?
Yes.
Okay, and did you have any objections to those documents?
I do not.
Okay, once we go on the record, we will enter those as evidence. And then for our presentations, Mr. Gozlan, you'll have 10 minutes, and then franchise tax board will have 10 minutes, and then Mr. Gozlan, you'll have 5 minutes to respond to anything from the franchise tax board. Is there any questions from anyone before we go on the record?
I do have a
Mr.
question.
Yeah, go ahead.
Do you want me to cite all of the different codes as part of my exhibits, or should I just kind of skim over that since you already reviewed it?
Yeah, we have them all. So we have all the documents here with us, and we also have access to the tax code. So if it's easier for you to just reference it, we'll have it.
Okay, just for the sake of time, I don't want to waste a lot of your time.
Oh, you're fine. We have plenty of time.
Okay.
But we do have everything you've sent in.
Okay.
And everybody was emailed those documents beforehand.
Okay.
Great, thank you. Any questions from Franchise Tax Board?
No questions, thank you.
Okay, well, Ms. Alonso, are you ready to go on the record? Okay. We are now on the record for the appeal of Gozlan, OTA case number 230914320. It is 1:12 p.m. on September 18th, 2024. The appeal is being conducted electronically via Zoom, led by myself, Sarah Hosey. With me this morning are my panel members, Administrative Law Judges Teresa Stanley and Eddie Lamb. I want to remind today's participants and viewers that the Office of Tax Appeals is not a court, but is an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. OTA does not engage in any ex parte communications with either party. Our decision will be based on the arguments and evidence provided by the parties on appeal in conjunction with an appropriate application of the law. Again, we have read the briefs and examined the submitted exhibits, and we are looking forward to your arguments today. Can I please have the parties introduce themselves for the record, starting with appellant?
Hi, my name is Eric Gozlan.
Thank you, Mr. Gozlan. Can I get the Franchise Tax Board?
This is Vivian Ho for the Franchise Tax Board, along with my co-counsel, Maria Brosterhouse.
Thank you, Ms. Ho. The issue identified on appeal for today is whether Franchise Tax Board's proposed assessment for the 2012 tax year has been barred by the statute of limitations. Does this issue properly reflect what is at issue for today, Mr. Gozlan?
Yes, ma'am. Yes.
Thank you. Ms. Ho?
In the documentation appellant submitted on September 11th, labeled appellant supplemental brief, he also raised reasonable cause for abatement of the accuracy related penalty.
Okay, Mr. Gozlan, would you like to add some arguments regarding reasonable cause for abatement of the penalty?
Yes.
Okay.
Yes, I do. Yes.
All right. We will add that. Thank you for the clarification, Ms. Ho and Mr. Gozlan.
Thank you.
For the exhibits today, submitted with briefing in response to the pre-hearing conference minutes and orders, we have appellants exhibits 1 through 6 and respondents exhibits A through D. For the record, are there any objections to these documents, Mr. Gozlan?
No, there are no objections.
Thank you. Ms. Ho?
No objections.
Thank you. So the exhibits are hereby admitted as evidence into the record. Okay, are there any questions before we move on to the parties' presentations today, Mr. Gozlan?
No questions.
Ms. Ho?
No questions.
Okay, Mr. Gozlan, you have 10 minutes for your presentation today. Please begin when ready.
Okay, thank you. Okay, so my position on this issue is that the Franchise Tax Board failed to meet the statute of limitations by delaying their notice of proposed assessment until just days of the June 8th, 2022 deadline. I received the notice of proposed assessment on June 13th, 2022 via US mail, and there was no postmark date on the envelope. The date that is on the letter is dated May 23rd of 2022. My position is that the Franchise Tax Board claims that this is sufficient notice. My position is that this is not evidence of timely notice. I'm going to give you a little bit of quick background information on how I got to this point. I went through a contentious divorce between 2011 and 2014, where I was awarded full custody of our 3 minor children. I raised them as a single father while also running a small business. The divorce caused extreme financial hardship, and I could no longer afford the mortgage payments on the family home. I applied for a loan modification, but it was denied. I had no choice but to either foreclose or do a short sale. I opted for a short sale, and the house was sold in 2012. Chase granted me a $208,000 forgiveness of debt, which I claimed on my 2012 tax return. In 2014, I went through an unexpected IRS audit for my 2011 and 2012 tax years. I had never been audited before and found the timing peculiar. Interestingly, the auditor kept asking questions about my divorce. I later found out that my ex-wife had contacted the IRS as a whistleblower to have me investigated. The examination was finally closed in 2016. The auditor could not find any wrongdoing, however, decided to disallow the $208,000 forgiveness of debt that Chase granted, even though I complied with the rules of the short sale. I was ordered to pay federal taxes and accrued penalties and interest on that amount. I later applied for an offer in compromise in August of 2016 and was granted a settlement, which I paid in full on October 24th of 2017. The evidence of that can be seen on my IRS transcript, which is part of Exhibit 3. 6 years after the IRS examination was closed, I received on June 13th, 2022, a notice of proposed assessment from the Franchise Tax Board via U.S. mail. The notice is dated May 23rd, 2022, stating that I owe $13,614 plus 10 years of accrued interest and penalties in the amount of $11,864.
Mr. Gozlan,
Yes.
sorry to interrupt. Can you slow down just a little bit with the numbers and everything? I just want to make sure we
Oh,
get
I apologize.
everything. No, you're doing great. Just a little bit slower for our stenographer.
Yeah, I just realized we have 10 minutes, so I'm just trying to, cram it all in 10 minutes.
It's okay. Slow down. We'll be, I think we'll be okay on time.
Okay, yeah, I'll slow down.
Thank you so much.
Do you want me to repeat? Sorry.
No, just after that last number you did. I think we got to the last number and then start there.
So 6 years after the IRS examination was closed, I received on June 13th, 2022, a notice of proposed assessment from the Franchise Tax Board via U.S. mail. The notice is dated May 23rd of 2022, stating that I owe $13,614 plus 10 years of accrued interest and penalties in the amount of $11,864, which you can see on Exhibit 1. I submitted my timely protest on July 16th of 2022 on the basis that the notice was not timely and unreasonably late. The FTB claims that they received the federal audit information from the IRS on June 8th of 2018, which is 2 years after the IRS audit was complete, and that they had another 4 years until June 8th of 2022 to meet the statute of limitations. The Franchise Tax Board also claims they mailed the notice on May 23rd of 2022, yet there was no postmarking from the Postal Service on the envelope to substantiate this claim. And I've referenced Exhibit 1, which is the original envelope that I received from the Franchise Tax Board. I will attempt to demonstrate that the Franchise Tax Board failed to reasonably meet the 4-year statute and should be subject to the same postmark rule and measure imposed on the taxpayer by both the IRS and the Franchise Tax Board. They shouldn't have rules for thee, but not for me. This would not be fair and equal application of the law. So my position, the Franchise Tax Board's position states on their January 24th of 2023 letter, which is part of Exhibit 2, they say on that letter, since our notice was mailed on May 23rd of 2022, it is within the statute of limitations date. On page 3 of their opening brief, they state there is also no California authority that requires FTB to provide postmark date in order to demonstrate the timely mailing of a notice. The FTB also states on their letter, which is part of Exhibit 2, that California law is the same as federal law for the issues involved. So my position is that the Franchise Tax Board is contradicting itself in these statements, and I will attempt to demonstrate that there is both California authority for the postmark rule, as well as the federal IRS Code 7502A contains a provision and an exception for the postmark rule as evidence of timely mailing. If you would refer to my Exhibit 5, which includes the IRS Code 7502, regarding timely mailing of documents and general rule as U.S. postmark stamped on the cover of a document shall be deemed to be the date of the delivery. And then I also include an IRS memo, which is part of my exhibit, entitled Received Date Procedures for Mail. Can I refer to it? On paragraph 3 of that memo, as part of my exhibit 5, it says, and I'll just try to go as fast as I can. It says, the evidence of timely mailing is a postmark date on or before the due date, whether the postmark is applied privately or by the U.S. Postal Service. And then it says, due date is confirmed by the requirement that the document be delivered within a reasonable time. And then below, on paragraph 5 of that same page, there's a reference to a case versus Grossman versus Commissioner, which states that the tax court accepted a petition as timely when delivered 50 days after the due date due to the Postal Service delays. And then I refer to the next memo, IRS memo on the next page, which also talks about USPS delivery confirmation. The third paragraph of that states the general rule for when a document is considered filed is when the document is physically delivered to and received by the service. Section 7502A of the code provides an exception to this general rule if a document is delivered by the U.S. Post Office, received by the service after the prescribed date, and the envelope in which the document is delivered is postmarked on or before the prescribed due date. In such instances, the filing date is deemed to be the postmark date. So that timely mailing is considered timely filing as the postmark rule. The Franchise Tax Board and the OTA websites are also replete with references about time-sensitive notices and how documents must be postmarked, certified, or with tracking info in order to be considered timely. If you would refer to my Exhibit 4, it includes several screenshots and printouts from the Franchise Tax Board website, as well as Franchise Tax Board procedures that outline all of these things about the postmark date and so forth. As well as California Code of Regulations, Title 18, 30205 OTA rules, which also talks about date of mailing. So I won't labor you with all of those, but it's replete with that information. I also want to just refer to the latest submission, which is the California Tax Code 19050, which I discovered after the fact, which is part of my Exhibit 5, which basically says a certificate by the Franchise Tax Board or of the board, as the case may be, of the mailing of the notices specified in this article is prima facie evidence of the assessment of the deficiency and of the giving of the notices. The Franchise Tax Board failed to provide such a certificate of proof of mailing. A printout from the taxpayer information folder system does not meet this requirement. Once again, in my assessment, the date on the Franchise Tax Board notice is not proof of timely notice. So I'm done with my presentation, other than the fact that I also, as my supplement, I have the reasonable cause and faith exception that I also want to present in the event that Your Honor doesn't rule in my favor. I want to fall back upon that as a fallback plan for some financial relief. Would you like me to go into that or wait for that later?
Well, you have a couple minutes left now, and you also have your 5 minutes on rebuttal. Would you like to address it now or in response to Franchise Tax Board?
I can do it in response to Franchise Tax Board.
Okay. Thank you so much, Mr. Gozlan.
Thank you.
The Franchise Tax Board, are you ready for your presentation? You also have 10 minutes.
Yes, thank you.
Thank you.
Good afternoon. My name is Vivian Ho, I, along with my co-counsel, Maria Brosterhouse, represent respondent, the Franchise Tax Board. The issue in this appeal is whether appellant demonstrated FDB's assessment for tax year 2012 is barred by the statute of limitations. At issue is also the accuracy-related penalty. FDB's assessment is based on a federal adjustment and is timely under California law. Appellant's account transcript, which appellant provided as his Exhibit 3, shows that the IRS examined appellant's tax return and made adjustments on July 11, 2016. Under Revenue and Taxation Code, Section 19059, when a taxpayer or the IRS notify FDB of a final federal determination more than 6 months after the determination, FDB has 4 years to issue a notice of proposed assessment. Appellant did not notify FDB of the federal determination. IRS notified FDB of the federal determination on June 8, 2018, which is more than 6 months from the final determination date of July 11, 2016. As such, the issuance of FDB's Notice of Proposed Assessment on May 23, 2022, which is within 4 years of the IRS notification, is within the statute of limitations for assessment. Appellant asserts that FDB has not demonstrated that the assessment is timely by providing proof of mailing, such as a certified mailing receipt. Appellant also cites to Revenue and Taxation Code, Section 19050, which states that a certificate by FDB is prima facie evidence of mailing. While a certificate of mailing constitutes prima facie evidence, under Revenue and Taxation Code, Section 18416, FDB is specifically allowed to send any notice by first-class mail. The same code section also specifically provides that FDB's notice requirements are satisfied when it sends a notice to the taxpayer's last known address. As confirmed in Appellant's Exhibit 1, the Notice of Proposed Assessment was sent to the same address Appellant reported in his opening brief. As such, FDB has satisfied its notice requirements for the issuance of the Notice of Proposed Assessment. Regarding Appellant's claim that fairness dictates that FDB and the taxpayers be treated equally in regards to the mailing rules. The FDB and the OTA have to adhere by the law as set by the legislature and cannot stray from the legal authority. In Appellant's supplemental petition, Appellant also raises reasonable cause for abatement of the accuracy-related penalty. The arguments Appellant raised does not establish reasonable cause. Under Revenue and Taxation Code, Section 19164, which conforms to federal law, the accuracy-related penalty may be abated to the extent that a taxpayer shows that they acted in good faith and had reasonable cause for the understatement of tax. Appellant in his supplemental petition only discusses his interaction with his attorney regarding the federal examination of his 2012 tax return. However, issue for abatement is not Appellant's conduct during the federal examination, but whether Appellant had reasonable cause for his failure to report the income at issue on his original tax return. Appellant did not provide any reasoning or documentation as to why he underreported his income on his tax return and has not established reasonable cause for abatement. As such, Appellant has not demonstrated respondent's determination is in error, and respondent respectfully requests that its determination be upheld. And thank you. I can take any questions the panel may have.
Thank you, Ms. Ho. We're going to wait for questions from the panel after Mr. Goslin's rebuttal. Mr. Goslan, would you
Yes.
like 5 minutes for a rebuttal? Or to address any other issues you'd like to address?
Yeah, so with regards to my supplemental petition for reasonable cause and good faith exception, I want to draw your attention to the IRC code 6664, which states that one of the factors in determining reasonable cause is that its courts generally apply a three-pronged analysis to establish whether a taxpayer acted with reasonable cause in relying on professional advice. Number one, the competence of the advisor. Number two, the taxpayers supplying all necessary information to the advisor. Number three, the taxpayer's actual reliance on the advice. In determining whether a taxpayer exercised ordinary business care and prudence, you should consider all the facts and circumstances and review all available information, such as the taxpayer's stated reason, compliance history, length of time, and circumstances beyond the taxpayer's control. So in my situation, on January 30th of 2015, I hired a tax attorney by the name of Brent Lance to represent me in connection with my IRS audit related to my 2011 and 2012 tax returns. This attorney has over 40 years of legal experience. I have never been audited before. I've never been imposed a penalty for late filing. I never went to college, nor do I have any experience or education with accounting or tax-related issues. I relied solely on the professional advice of my tax attorney on all matters related to the course of these issues.
Hey, Mr. Goslan?
Yes.
Sorry to interrupt you. Just you're providing some factual background,
Yes.
and I'd really like to swear you in so we're able to use your testimony today in our decision making, if that works for you.
Can you repeat that last thing you just said?
Sure, yes. Since you're providing some facts for us to use in making a determination regarding reasonable cause, I'd like to swear you in so we can use your testimony under oath.
Sure.
Okay, we
Yeah.
can do that and then it will count for the whole hearing, so we don't have to go back.
Oh,
You can
okay.
continue on. I just want to be able to use these facts if we need them at a later
Yes.
date.
Of
Okay.
course. Of course.
Mr. Goslan, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please continue. Thank you.
Okay. So I relied solely on the professional advice of my tax attorney on all matters related to the course of these issues. My attorney advised me that the IRS would be notifying the state of California on all federal adjustments made to my returns. I was never instructed to contact the FTB or to do anything further by my counsel. And I want to refer you to Exhibit 6, which is correspondence between me and my attorney regarding the completion of my IRS audit. And he states in this exhibit that let's see, he spoke with the AO yesterday concerning the issue we discussed. He says there is a unit within the IRS whose job it is to liaise with state tax authorities concerning the adjustments the IRS makes, as well as the adjustments made at the state level that may indicate more federal taxes due. That said, he said he has heard from other taxpayer representatives that the system doesn't always work as designed and that some IRS adjustments apparently never get notified to the states. He is not aware of why the system only works as designed sometimes. My guess and operating assumption has always been that the state of California will be notified. And then when I later reached out to him to ask if there was any evidence of, I needed additional evidence in this situation as I was facing the FTB notice, he emailed me and said, Eric, I found this email. I was looking for closing letters in my electronic files. It confirms our discussion that the state of Closing would most likely contact you at some point for tax on the adjustments made at the federal level. Hopefully it will turn out that they really waited too long to do so. So my point is that in regards to, my relationship with my attorney, I had a falling out with him over excessive hourly fees and some bad legal advice, and ceased doing business with him. I later filed for a federal OIC on my own and was granted a settlement amount due to financial hardship, which I already mentioned. I paid everything in full with the IRS and never knew I was required, and I never knew that I was required to contact the FTB. So I relied on the information from my attorney that the federal agencies would be contacting the state with all of that information. So based upon that reliance of information on my professional attorney, I should be entitled to the reasonable case exception relief provided under IRC 664 on the basis that I exercised ordinary business care and have made reasonable efforts to determine the correct tax obligation while relying in good faith on the advice of my tax attorney. It turns out that this advice was erroneous and misleading. So in closing, I was unaware that it was on me to reach out to the Franchise Tax Board and give them anything more than what the federal agency already had. So that's my fallback as far as, if my presentation doesn't go my way, I'd like to have that as my fallback to try to get some level of relief on all of the accrued penalties and interest.
Thank you, Mr. Gozlan. I'm going to ask Ms. Ho, does the Franchise Tax Board have any questions for Mr. Gozlan regarding his testimony?
Yes. Mr. Gozlan, when you are filing your 2012 tax return, did you receive any professional advice regarding matters of substantive law?
Can you be more specific? I had a CPA file my tax return, so I had a CPA.
Were you advised how to treat certain items as income or not?
It's very vague. You have to be more specific.
I think more specific. I think what Ms. Ho is getting at is the income that was added back as a result of the IRS audit.
Yes.
Were you specifically advised that that income was excludable income?
Yes. In the filing of 2012, my CPA advised that the forgiveness of debt on the short sale was not going to be income added back. It was going to be a write-off on my taxes. So that was under the advice of the CPA. And that was the only reason that I did the short sale. Otherwise, I could have just walked away from the property and allowed them to foreclose. I did the short sale to try to work in good faith with the bank and to do everything by the book. So, yeah, I did everything under the advice of my CPA. He was aware of the short sale, and it was supposed to be a forgivable debt.
Any other questions from the Franchise Tax Board?
No further questions. Thank you.
Okay, thank you. Thank you, Mr. Gozlan. I'm going to turn to my panel now. Judge Stanley, are there any questions for the parties?
This is Judge Stanley speaking. Yes, I did have at least one for the Franchise Tax Board. Mr. Gozlan mentioned Revenue and Taxation Code Section 19050. Can you address whether and how that might apply to the facts of this case?
Yes. While the Franchise Tax Board could establish the mailing of a notice through a certificate, while that certificate will be prima facie evidence, Code Section 18416 also provides that FDB satisfy its notice requirement by sending a notice to a taxpayer's last known address. So while a certificate will be prima facie evidence, it does not preclude FDB from establishing mailing of a notice through other means.
Okay, this is Judge Stanley speaking. I don't have any further questions. Thank you.
Thank you, Judge Stanley. This is Judge Hosey again. I'm going to ask Judge Lamb, are there any questions for the parties?
There are no questions from me. Thank you.
Okay, thank you. Mr. Gozlan, is there anything else you'd like to say before we close the hearing for today?
Sure, I'd like to make a little closing argument.
Just briefly, yes. Go
Yeah, it's very
ahead.
brief. Yeah. So my closing argument is very brief. Due to the time sensitivity of meeting the statute, you would think that the Franchise Tax Board would take greater care to ensure the timely notice of their NPA. And I'm asking here for equal application of the law that should be applied here on both sides. The same standard and measure of timely mailing that the IRS and the Franchise Tax Board use should be applied to this case. Notably, the U.S. postmark rule should be applied fairly to all parties. Since the letter sent by the FTB was just within a few days of the statute deadline, and the envelope did not contain the U.S. postmark date on it as defined by federal statute, the FTB failed to perform timely notice and therefore was outside the statute of limitations. I hope that the judge will apply the law fairly and equitably for both sides. And if you, Your Honor, disagrees with my position to dismiss this case, then I would respectfully request consideration for at least waiving all the applicable interest and penalties that have accrued for the last 12 years. That's it.
Okay, thank you, Mr. Gozlan. Do I have any other questions from anybody before we conclude today? Okay, so the evidence has been admitted into the record, and we have the arguments in your briefs as well as your arguments and testimony presented today. We now have a complete record from which to base our decision. We will meet and confer and have our written opinion issued no later than 100 days from today. I wish again to thank the parties for their efforts in this matter. And with that, we are off the record. The next OTA hearing shall begin